Civil procedure, the trial phase. There is a right to jury trial in the U.S. Constitution. It's in the 7th Amendment, the Bill of Rights. However, the right is limited to federal courts and civil trials at law, not equity. The right to jury must be asserted in writing, either in a pleading or a separate document. And the demand for jury trial must be made within 10 days of service of a pleading containing issues qualifying for jury. Now that both law and equity cases are decided in the same court, the jury is used to decide issues of fact as they relate to damage claims. Then the judge alone decides on injunctions and other matters of equity. If both parties have contributed to the configuration of the jury, it's thought they will find its verdict more acceptable. So the parties have a right to reject unwanted jurors. Each party has a right to reject an unlimited number of prospective jurors showing bias, prejudice, or some other cause. They also have the right to reject up to 3 prospective jurors where no evident cause is shown. The parties rejecting the juror with such a peremptory strike does not need to explain the reason. However, constitutional law prohibits discrimination on the basis of race or gender. Judgment as matter of law is a directed verdict by the judge, regardless of the decision of the jury. This is where the power of the judge trumps that of the jury. The motion for judgment as matter of law must be brought at the close of all evidence. Otherwise it's waived and cannot be brought again after the decision of the jury. The judge must consider that the evidence is so strong that reasonable people could not disagree on the verdict. The judge essentially says the case is so clear-cut there's no point in presenting it to the jury. The judge alone directs the verdict. In fact, this used to be called a directed verdict. A post-verdict motion used to be called a judgment notwithstanding the verdict, but this is now referred to as a renewed motion for judgment as matter of law. This is renewed as it must be a renewal of the motion brought previously at the close of evidence. If the motion was not brought before it went to the jury, the right was waived and cannot be brought after the jury's decision. A judgment as matter of law usually results in a complete new trial of the case, either in trial court or in appeals court, as cases decided in this way have to be considered de novo on appeal. Federal Rule 59 allows for a motion requesting a new trial no later than 10 days after the entry of the judgment. A new trial can be ordered based on various grounds such as errors at trial, like incorrect rulings over the admissibility of evidence or incorrect jury instructions. New evidence becoming available that could not have been made available at the first trial. Misconduct by a party, judge, juror, attorney, or witness that is prejudicial to the verdict. And a serious judgment of error by the jury. If the judgment was against the weight of the evidence, the judge can overrule the verdict by making a judgment as matter of law. Alternatively, a new trial can be ordered where the facts are presented to a different jury. The Court of Appeals are established to consider cases after they've been through the entire process available at trial court. The final judgment rule is a general rule that appeals can only be taken from a final judgment. An appeal from most pretrial orders is typically considered interlocutory, temporary or provisional, and therefore not appealable. Parties cannot appeal motions at trial, such as a denial of motion for summary judgment, as the trial court has not yet completed its process. A grant of motion for summary judgment is appealable, as it represents the ultimate decision on the whole case. A grant of a motion for new trial is not appealable, as the new trial will take place in trial court. Only when the new trial has had final judgment will the case be suitable for appeals court. The grant or denial of renewed motion for judgment as matter of law, where the judge decides whether to override the decision of the jury, is a final judgment, so it is grounds for appeal. An exception to the general final judgment rule involves motions for class action status. Within 10 days of the granting or denial of the motion, the decision may be appealed at the discretion of the Court of Appeals.